the day 3 debate match between University of Melbourne of Australia and University of Bologna of Italy. Welcome to the 2 participating teams. Welcome also to coach from one of the teams that is present currently in the session. My name is Anna Maria Urbanova on the behalf of Quarks Foundation, organizing the Hague Inter-University Law Debate Tournament edition 2023. I'm delighted to welcome you to today's session. Just a short introduction for the participants and for the audience and the judges. Today's debate statement was given to the teams at the same time. They had 7 days to prepare for the match. They do not yet know which positions they will be allocated. The statement for the match is, with the rapid integration of technology and ongoing innovation, digital rights should be constitutionally protected. So that would be it from me as the host of the match. I will be also reminding the teams of the speaking time. Yellow card indicates 30 seconds left of their speaking time. Red cards indicates their time is up, but they can still conclude their sentences. That would be it from my side. Passing the floor to the participants. Ms. Janine Bao of the University of Melbourne, the floor is yours.
My name is Janine, and I'm a second-year JD student in the Melbourne City.
Thank you very much. From University of Bologna, Mr. Alvarez Vega.
Hi everyone, my name is Luis Felipe Alvarez Vega. I'm originally from Costa Rica and I'm a student in the Master's in Legal Studies at the University of Bologna. I'm really excited to participate in today's match.
Thank you and welcome Mr. Ilan of University of Melbourne.
Hi everyone, I am Elon. It's very nice to meet you all. I'm originally from New York City. And I am a third-year student at the University of Melbourne.
From University of Bologna, Ms. Maria Gabriele Paiva Barbosa.
Hello, good morning everyone. My name is Maria. I do legal studies at the University of Bologna, and I'm very excited to be here with you all and debate on this relevant topic.
Thank you. Welcome, Ms. Emma Doctor.
Hello everyone, very nice to meet you, Australian team. I'm Emma, I'm from France, and I'm a first-year law student in the Master of Legal Studies in Bologna.
Thank you and welcome. And welcoming in this session also coach of the University of Bologna team, Ms. Yeva Malikaita, who's also the former participant of the last year's edition.
Hello everyone, very nice to meet you. I'm Yeva and I'm a second-year legal studies student at the University of Bologna.
Thank you and welcome. So shortly you will see the screen to decide the positions for the 2 teams. Please, if you can just confirm when the screen is visible to you. All right, thank you. So just a short click away and we'll have our positions. Thank you very much. So for today's session, the against position is assigned to the University of Bologna and in favor position is assigned to University of Melbourne. Just to shortly rephrase the statement that the teams will be defending. The University of Melbourne will be defending that with the rapid integration of technology and ongoing innovation, digital rights should be constitutionally protected. Whereas the University of Bologna will be arguing that despite the rapid integration of technology and ongoing innovation, digital rights should nevertheless not be constitutionally protected. You will now have 5 minutes to finalize your preparation. Feel free to close your cameras and comfortably prepare. Right, the time for preparation has now passed. Starting with University of Melbourne, which is the in favor position. You now have 4 minutes for your opening statement.
Dear Judge and colleagues, with the rapid development of technology and ongoing innovation, the protection of digital rights becomes more and more important. In the digital age, law needs to be more adapted to protect and safeguard the fundamental rights. Digital rights are an extension to those rights set out in the Universal Declaration of Human Rights by the UN, which applies to the online world. Digital rights include the rights to access, freedom of expression, data protection, and privacy, and so on and so forth. The core problem here is who should be more responsible to protect them. From our perspective, digital rights should be constitutionally protected based on 3 key principles. First, it is the government's responsibility to protect their citizens in relation to privacy and cybersecurity. Sometimes the standard of privacy and what kind of personal data is to be protected may vary from state to state. It would be more effective to regulate and pass legislation to protect the citizens. Furthermore, if we don't have a constitution level of protection, there is no direct way to sue for data breach or cyber attack. It is even more challenging to take enforcement actions against wrongdoers. Secondly, lack of international consensus urges each state to take their first step and the necessary step to protect their citizens' rights, instead of waiting for an international level consensus to be reached, which will take forever to resolve the real problem. Take the European Union as an example. In 2018, the General Data Protection Regulation came into effect. It is easier for the member countries to comply with the regime for the benefit of preserving citizens' personal data and allowing free movement of the data in a more secure manner. The third point I want to touch on is, since the substantial corporates hold the most of data, it requires an international level of legislation, a constitutional level protection, rather than just general legislations. As of January 2023, more than 120 countries in the world have similar legislations protecting personal data and their access to the information on the internet. This is consistent with some key recommendations from the UN's roadmap to address the concern that the digital technologies are too often used to violate the human rights rather than to exercise the human rights. Therefore, considering that digital rights now becomes part of our social life, the widespread application of the new technology has highlighted the urgency for the government to take action to protect their citizens. As such, those rights should be constitutionally protected. Thank you.
Thank you for your submission. University of Bologna, you now have 4 minutes for your opening statement.
Good morning, ladies and gentlemen, esteemed panel, and dear opposition. On behalf of the University of Bologna, we argue against the proposition. Digital rights should not be constitutionally protected. To begin, it is important to establish a self-evident truth. The digital realm, which encompasses computers, mobile phones, the internet, the metaverse, and other upcoming technologies, are and will stay part of human society. We're undergoing a data revolution. From online shopping to social media to banking and healthcare, our personal data has been increasingly tracked, collected, stored, and used by companies and governments alike. In view of this reality, we would like to establish a common ground with the opposition today. and highlight the importance of protecting and upholding digital rights. However, constitutional protection is not the most effective or conceivable way to achieve this. We'll expand this by way of 3 arguments. First, coordination, sovereignty, and the procedural and political hurdles of constitutional reforms. Digital technologies are global in nature and they transcend national borders. However, many jurisdictions have inexistent or outdated laws to the rapid expansion of technological advances. In a globalized digital world, this is not conceivable. International law allows for a coordinated level of protection of fundamental rights and minimum standards to be achieved at a global scale. In support of the rule of law, internationally safeguarding digital rights allow for mechanisms of accountability to hold governments and companies accountable for breaches. Moreover, constitutional reform in many states is practically impossible from a procedural and political point of view. Even if achievable, requiring states to enact their own level of protection at the constitutional level entails that digital rights will be unequally protected. In addition to the procedural and political hurdles of constitutional amendment, states have full sovereignty to constitutional reform. For instance, Australia does not have a Bill of Rights or a Fundamental Rights Charter in its federal constitution. However, it has ratified several international human rights treaties, including the ICCPR, and it should be held to the obligations set therein. This demonstrates how constitutional guarantees does not equal fundamental rights protection. The right to freedom of expression is a universally recognized human right, found in Article 19 of the ICCPR and Article 10 of the European Convention on Human Rights. In Delphi v. Estonia in 2015, the European Court examined the right to freedom of expression of an online news portal, and it found that the internet allows for rapid dissemination of information, and service providers should have the responsibility to oversee infringements on the rights of others. This case does not only expand the scope of the right of freedom of expression to the digital realm, but it also provides for limitations. The right to privacy is also a fundamental right safeguarded by several human rights conventions. Unlike the right to freedom of expression, jurisprudence has construed that the right to privacy is also enjoyed in the digital realm. In Google Spain, the ECJ stressed the importance of protecting individuals' privacy rights in the digital age, and it recognized the globally applicable right to be forgotten. This demonstrates that digital rights have been construed as an extension of fundamental rights and should be protected as such. This can only be done through interstate cooperation and treaty ratification, which binds states to common standards of protection. A model to be followed is the EU's GDPR, a directly applicable and wide-encompassing instrument that set out strict rules for the processing of personal data as well as for accountability mechanisms. This approach is favored in view of the principle of sovereignty, the hurdles of constitutional amendment, and effectiveness. We rest that with the rapid integration of technology and ongoing innovation, digital rights should not be constitutionally protected. Thank you.
Thank you for your submission. Entering now the rebuttals. University of Melbourne, you have 2 minutes for your first rebuttal.
Thank you. So I just want to reply to the colleagues about why an Australian don't have human rights. I think that's because we respect human rights is the fundamental right. We don't intend to interfere. That's one of our well-established principle of statute interpretation. So our legislation does not intend to interfere fundamental rights, but offers the protection for our citizens. And I want to focus on the freedom of expression. So from ICCPR Article 19 states, everyone shall have the right to freedom of expression. Our legislation does not intend to interfere with that. And also on the constitutional level of protection, we can set up a clear boundary to protect the rights of freedom with the limits. Therefore, people can not only enjoy the freedom of communication, but also be protected by the government from those illegal actions on the internet, for example, online violence and some online illegal content. Secondly, I want to focus on the cybersecurity. It is foundation for the individual to exercise their digital rights. Consider if the company sells or discloses your personal information to others, or there is an unauthorized access to the data. If your country already have the legislation, it is easy for them to investigate the data infringement and impose sanctions. To sum up, digital rights should be constitutionally protected, especially in the situation when the digital rights are violated. Thank you.
Thank you for your submission. University of Bologna, you have 2 minutes for your first rebuttal.
Thanks, team from Melbourne, for your submission. So from the arguments exposed by them, I think you are sort of solidifying our view that international protection is a better way to protect digital rights than constitutional protection, since in the example illustrated by Australia, the Australian government actually respects more the international protection than having the need to have constitutional protection. So I feel like that is a solid ground to argue that the protection should be international and not constitutional. Beyond that, also what my colleague said about the burdens of constitutional reform, in many cases it's really impossible to conduct a constitutional reform. For example, the case of the US, in which, if anything, there have been around 30 constitutional reforms, and that's like a really prominent country for international companies that deal with in the digital market. So their citizens would be unprotected. Additionally to that, we want to highlight the international and supranational nature of the digital phenomenon, and argue that the right way to protect it should be an international or supranational convention. And a perfect example of the effectiveness of these measures is the GDPR, as both teams have stated and have praised, which is a norm that has a human-centric approach to the protection of digital rights. Furthermore, the international amendments is a form that accounts for international differences. For example, it's a way to protect digital rights in countries that have a common law or a civil law system. So for this and the other reasons exposed, we believe that international protection is more adequate for digital rights protection. Thank you.
Thank you for your submission. University of Melbourne, you have 2 minutes for your second rebuttal.
Thank you for those points, the University of Bologna. I respect your esteemed opinion. However, in the UN, Secretary General for an International Code of Conduct for Information Security that was submitted in 2011 by the representatives of Russia, China, Tajikistan, and Uzbekistan has still failed to be implemented. On the other hand, you see the constitutional protections regarding digital sovereignty, like the United States. In the case of Carpenter versus the United States, a man who had his information hacked by the government through a corporation, Tower, which was T-Mobile, that information was hacked and used to foster his arrest. In that seminal case, the Supreme Court of the United States said that the Fourth Amendment of the United States Constitution, again, a sovereign nation's constitution, not an international agreement, protected this man's rights. And in that statement, Chief Justice Roberts said, the Fourth Amendment has afforded law enforcement a powerful new tool to carry out its important responsibilities. At the same time, this tool risks government encroachment of the sort of that the framers of the US Constitution set out when they drafted the Fourth Amendment to prevent. Without the Constitution, this man was going to prison for many, many years because of the government's abuse of his digital rights. Therefore, a constitution is necessary from a sovereignty level where you get to protect digital rights in an internal level, and then you could work from the outside. Without an internal constitution, you suffer to get your rights abused because you could take your case to the International Court of Justice, and that could take 10 to 15 years. But that mechanism within a country, within its own courts, if you are able to sue for that right through a country's constitution, like the Fourth Amendment in the United States, you then have a better chance of success.
Thank you for your submission. University of Bologna, you have 2 minutes for your second rebuttal.
Thank you, team, of Melbourne, from your submission. I feel like the point illustrated by the team's counsel is also could be used as an argument in favor of international protection, since in the case of the US, there has not been a particular US amendment, a constitutional amendment regarding digital rights. What's being done is more of judicial activism in order to protect the digital realm. So this is already something that exists in most countries, and we could argue that judicial activism is already a way to protect digital rights in the national realm through the existing constitution, through like a derivative approach to the existing constitution. But then this doesn't really mean that there needs to be a constitutional reform to protect the digital rights. And then this doesn't really account for the international realm and the international implications of digital rights. For example, a constitution cannot really mention or like address a way to deal with international how would we say, breaches of data or interference from another country regarding digital rights, which has already happened, for example, in the US in the case of the Russian intervention on the US election in 2016. Activism, as I said, can already be done, and that doesn't really mean that there is a right for constitutional amendment. Definitely, international legislation should take inspiration from pre-existing legislation, but that does not mean that we should not seek a way to internationally regulate an international phenomenon, as a national regulation would not be sufficient. Thank you.
For your submission, the University of Melbourne, entering now the conclusions, you have 2 minutes.
Thank you so much, esteemed judges and colleagues from Bologna today. It's been a pleasure having this debate with you. However, I must disagree with the last point that was offered of an international summit for peace and regarding technology. I just don't see how that is a possibility when you have countries that cite data as cybersecurity and technology as a threat to their sovereignty. That means that these countries will never agree to an international platform where countries will assert a right over their own sovereignty. Digital rights can only be protected on an individual level, and you see that with the disagreements between Arab nations, China, and the US. Each one views technology in a different way. Some view technology as a form of repression, while others view technology as a form of freedom. In the international sphere, to sign on to a treaty, you must be a signatory. You cannot just say that, oh, we are putting together a new international summit for technology. If countries disagree and don't sign on as signatories, that's just another element of legislation that just gets lost in the wind. But if you have a ground up type of functioning where society in general says we must protect our individual rights from the government or from corporations like Google, Apple, Meta, who control 8% to 20% of the world's internet, you need that on an individual level. So while it's nice to say we can protect everything internationally, if countries don't decide to be signatories, then that legislation becomes irrelevant. Thank you.
Thank you for your submission. University of Bologna, you have 2 minutes for your conclusion.
Thank you for your submission, ladies and gentlemen, esteemed panel in the opposition. In this debate, the opposing team argued that with the rapid integration of technology and innovation, digital rights should be constitutionally protected. However, we have explained on several points why international treaty and supranational means would be a better option. Even though we agree that maybe some country would be reluctant to commit to international agreement, there are several options to still implement those solutions. We could expect some states to make reservation to international treaty, but still take commitment to protect digital rights. And if countries are not willing to sign such supranational means, how can we expect them to amend their own constitution to protect rights that they are not willing to protect in a supranational level? That's a paradox that we need to clear out. But we support the position that those rights should not be constitutionally protected because it's not the most ideal solution. It's not necessary. Human rights treaties are proven to be more effective, also in harmonizing the protection among several states. We also emphasize the fact that there is many hurdles for constitutional amendments in various levels. And we stand by the fact that to promote and really ensure international equality and turns into opportunities or the possibility of the digital realm, it's better to have international protection rather than a variety of more or less close constitutional definition. Thank you very much for this debate.
Thank you very much for your submission. And this marks the end of today's session for the day 3 of the Hague Inter-University Law Debate Tournament for your group. It also marks the final match in the group phase for the Bologna team. Possibly, just for the point of information, the debate team of University of Melbourne jumped 2 wins first in the second round, since they had a later start in the academic year. So there was a bit of postponement in regards to day 1 match. On the side of organizers, allow me to say well done on your research and the execution of your research during the session. Good job, especially with the shortened format that we use in this competition. It really showed your ability to adapt and flexibly present your arguments. So we are now in the feedback session. You can relax. Just a short reflection on your preparation for the match and how did you experience the match, and perhaps did you already encounter this in your studies? Starting with the University of Bologna. Mr. Luis Felipe Alvarez Vega, how did you find the experience?
I hope everyone's doing well and that everyone enjoyed the debate. Yes, so I think I've mentioned this to you before, but this is my first time in a debate competition like this. It's been really exciting so far, to be able to learn from each match and how to improve in each match. And I really like this topic particularly, so I was very passionate while doing the research. So it's really gratifying to be able to debate on something that you feel passionate about. So yes.
Thank you. From University of Melbourne, Mr. Ilan, how did you find the experience?
Thank you again. The University of Bologna, it was great having this match with you. I hope your coffee is nice this morning. We're all ready for bed here in Melbourne. But we found the match very insightful and engaging. We were impressed with how you knew a lot about Australian law. We also, from the University of Melbourne, we have to thank our coach, Wayne Jokic. He's a construction lawyer by expertise, so he's been very influential on the international boundaries that just cross everywhere. But we really enjoyed the match today, and thank you.
Thank you very much. From University of Bologna, Ms. Maria Gabriela Paiva Paposa, how did you find the experience today?
Hello, I found today's debate very nice. I found that the other team had very good, solid arguments, which we were, not expecting, but we hope to have managed to circle around it. I am so glad to have debated with the Aussie team in this competition because I lived in Canberra for 3 years. So it's very, it's interesting, and I had a great time in this debate. This was a topic that also really sparked my interest. So enjoyed it.
Thank you. And that also kind of jumps in for the final question of the session, where if you have visited each other's country, but still on the feedback of the session, how did you find the preparation, the match? Ms. Bao from University of Melbourne.
Thank you. I want to echo on Yin. So I will thank you, our coach. So he is really helpful and build the foundation for us. I'm really excited because Italian cuisine is one of my favorite cuisine. So I'm really glad I can have a match with Italian university. Thank you.
Thank you very much. And Ms. Emma Batto, how did you find the experience, the preparation part?
Thank you, everyone. I think we're getting more confident as a team. That's our fourth match, even though we had one that did not happen. But the preparation is getting better. We're getting more confident, and I think we're like all three, and also our coach, really excited for this match. And yeah, I have to thank the Australian colleague. That was really interesting, and I don't know how to phrase it, but I really liked the closing statement of the opposing team, and I tried to, I don't know, I completely changed my way to do my closing statement to react. So thank you for the inspiration, and yeah, we hope to see you again in the competition later.
Thank you very much. Ms. Eva Malikaita, as a coach of the Bologna team, how did you find this round?
I found it really, really interesting. I don't know if there's echo as well. Yeah, I found it super interesting. It was very exciting to watch it. I think both teams were very well prepared and they had very good arguments. I mean, I was very excited to watch the Unibo team. They were doing great and I was very proud. But the Australian team did amazing as well. So well done, both of the teams.
Thank you very much. And finally, perhaps a traditional question that we have in these past editions of the competition is to ask both teams if you have perhaps visited the city and or the country of the opposing team. So we already heard from Ms. Maria that you had a chance to visit Canberra, lived there for a bit. So perhaps then starting with the University of Melbourne, did you have a chance to visit Italy or perhaps even Bologna?
I haven't had a chance to visit Italy, but I had a football teammate who was from Brindisi. So I know a little bit about the coast in Italy and obviously Serie A as well. So football brings us all together, I think. And yeah, so I've never visited Italy, but one day.
Ms. Bauer, did you have a chance perhaps already?
Transport is always on my list because I auntie lived in Switzerland, which is not too far from there. So yeah, one day I will definitely visit there.
Thank you. Hopefully one day, perhaps even a meeting between the two teams. For the team from University of Bologna, did you have a chance to visit Australia, perhaps specifically Melbourne as well?
I haven't, but I have a friend from Australia who is really nice and I love her a lot. So, no Australians.
Yeah, in the Australian accent. And I wish that I can come back and go to visit Melbourne because I only stayed, in the Canberra area, and I know it's not very exciting. I mean, I love it, but yeah, I plan on returning for sure.
And yes, same as Felipe, never visited Australia. It's a bit too far from France for now, but hopefully one day I can manage. And yes, Bologna is such like the university city by excellence in Europe, so you're very welcome to visit us and have a tour of the cuisine. even though I will try to prove you that the French cuisine is better. That's something else.
And also perhaps to Ms. Eva Malikaita, did you have a chance to visit Australia?
No, unfortunately not, but one day, hopefully soon.
All right, thank you very much for the two teams. Once again, well done on your round 3 debate. As promised, the recording of the session will be made available shortly after the match later today. You will be provided with the links. The next time your teams will see each other, of course, if you want, we are happy to provide the communication between the two teams. We have also had teams that reached out to each other on the social media, so we are happy to facilitate. But for sure, you will have a chance to meet during the networking session, which will be part of the mid-competition event, where the teams that participated will know who continues into the second phase of the competition. And it will be accompanied with the networking, so you'll be able also to interact with each other and, of course, learn who continues into the next phase. Right. Once again, well done. Have a good rest of the day and start to the weekend, everyone.
Thank you.
Thank you.
Thank you very much.
Bye.
Bye.